due to decrease in services for either their individual apartment or in the building common areas. Um, so starting off, we want to start with the service overview. Under rent regulation, an owner has to provide and maintain required or essential services to tenants. This includes repairs, heat, hot and cold water, maintenance, cleaning, janitorial services, elevator service, and any ancillary services such as a garage or laundry facility. Tenants who experience a decrease in services can submit a service complaint by filing form number RA 81, which is the application for rent reduction based on decreased services, individual apartment. For decreased services and building-wide services, tenants can file form RA-84, which is the application for rent reduction based on building-wide services. Tenants that have a heat or hot water issue can file a complaint on form HHW-1, which is our failure to provide heat and hot water. Now, examples of a decrease in service, they would include things like defective electrical outlets, broken windows, unsanitary conditions in the common areas like the halls and lobby, not being maintained or cleaned on a regular basis, broken door locks either on your individual apartment or in the entrance of the building. For complaints that deal with a lack of heat or hot water, you must first file a report with the appropriate city agency. In this case, it would be HPD. And a copy of that report has to be submitted, and we'll go into that a little later, with your application. That does not mean that we will not inspect for those issues during the process of the complaint. We will still inspect for it. However, when filing that complaint, you have to accompany it with a copy of what was issued by that agency. Now, the purpose of what we do with these reduction orders is to assist the tenant in getting the necessary repairs made. And by way of that, when we issue our order, what we may do is reduce the rent, freeze the rent, and direct the owner to make the necessary repairs. Now, generally, if you are in a rent-stabilized apartment, your rent will be reduced by the most recent guideline increase. And, you know, generally speaking, that would mean that if you're in a current lease and you filed a complaint for rent reduction, and when we issue that order, you would go back to the amount that was paid prior to you signing your current lease, and that amount would be frozen until the rent is restored. Now, if you're in a rent-controlled apartment, it's slightly different. We give specific dollar amount deductions based on the items that are found to not be maintained when you are under rent control. And this, one of the reasons that why this difference exists is because under rent control, you're a statutory tenant and you do not get renewal leases the way that rent stabilized tenants do. Another aspect is that if you are a tenant who's displaced from your apartment, it may be because of a fire or some other hazardous condition where a vacate order has to be issued for either just your apartment or maybe the entire building. In those cases, you would still file the same application for rent reduction. However, because you were forced to vacate, we would reduce the rent to $1 a month for the period that you're unable to stay in occupancy of your apartment. And this allows you to maintain the right to reoccupy that apartment once it's restored to habitability. So now we're going to go into a little more detail about the process. Now, as I said before, we process 3 types of complaints. Individual apartment complaints, which are docketed with an S suffix. So if you have a complaint and it has an S at the end, that means it's for an individual apartment. Building-wide have a B suffix, and heat and hot water have an HW suffix. We also process owner restoration cases that are filed by the owner when they want the rent restored, and those have an OR suffix to the docket number. Individual and building-wide complaints involving emergency conditions are considered code red complaints. And those cases are given top priority and assigned immediately. Now, just to go into a little more detail about the differences between the S and B cases, sometimes this happens, tenants aren't sure which one to file. If it is something specific to your apartment, that could only be filed under an individual apartment complaint. Building-wide complaints, as I said before, are for common areas of the building, the stairs, the roof, the lobby, maybe if your building has a courtyard, or if it's dealing with an ancillary service that exists outside of your apartment, such as storage provided by the owner, or as I said earlier, a laundry facility, or if you had a parking space that was taken away by the owner. Those would go under a building-wide service complaint. Another thing about the building-wide service complaint is that multiple tenants, unlike the individual apartment complaint, can join the building-wide service complaint. And that would have the effect of all of those tenants, should that complaint be granted, would all have their rents reduced and frozen together. And there's a supplementary form that gets attached where all of the tenants who wish to participate in that building-wide complaint would give us their information. Now, as far as the owner rent restoration is concerned, we will only restore the rent when the conditions cited in the rent reduction order have either been corrected, or if it's a situation where, if it's an individual apartment issue, the tenant has refused to provide access for the owner to make repairs. Now, other emergency conditions, other than, say, a fire that causes a vacate order, in which we would consider it a code red situation, would be absolutely no water or electricity apartment-wide. If you have an inoperable toilet, a broken or an inoperable apartment front door lock, if you have a fire escape and that window is stuck and won't open, collapsed ceiling, walls, a cascading water leak, or something that soaks electrical fixtures, which causes a hazard. So those are some of the things that we would consider a code red violation and would be given high priority. Now, let's talk a little bit about the actual process itself. Once the complaint is filed, the unit screens dockets, and serves the complaint to the other party. So if it's a rent reduction complaint, the owner is the person who gets served. If it's an owner restoration complaint application, the tenants are the ones who are served with a copy of the application. We have specific units. Before I say that, we do sort it based on severity of the issues, and we have designated units that handle specifically code red, heat and hot water, and vacate complaints, since those are given high priorities. Now, we have other issues that we consider urgent, but not code red. We call those code blue. And those issues would be something like vermin, an issue with cooking gas, or if you have an unworkable appliance. As I said earlier, in order to get a rent reduction on a heat and hot water complaint, you do have to give us that copy of the HPD violation. Now, once the complaint is served on the opposing party, each party is given a specific amount of time to respond. And it's going to vary based on the case type and how severe the issues are. Cases that are designated as fire or vacate, we give the owner 5 days to respond. If it's just a hot water or a service or a BK or a building-wide case that's designated as code red, but it's not a vacate issue, we give the owner 20 days to respond. Now, if it's a non-code red, just a regular complaint, whether it's for an individual apartment or a building complaint, if the tenant has provided proof that they've notified the owner, and I'll go into that a little later, we give the owner only 20 days to respond. However, if the tenant did not give the owner prior notification of all of the conditions in their application that they say are not being maintained, the owner would have a full 60 days to respond. All of our restoration applications filed by the owner, when they are served on the tenant gets 21 days to respond. And for tenants, when an owner files an application to restore the rent, it is vital that tenants respond to that notice and let us know whether or not the owner has made the necessary repairs. Now, after the time has expired for the person to respond, that's when the case is eligible to be assigned to an examiner. Again, if it's one of our code red cases, that will happen right away. If it's not, and the way they're sorted, the case will be on a first come, first served basis, but it won't be prioritized the way a code red case or even a code blue case might be prioritized. And then, as we'll go into a little later, the case processor at that point starts to send out notices and may request additional information or an inspection and whatever they feel they need in order to make a determination in that complaint. Now, I want to talk a little bit about the aspect of rent restoration. Now, this is where the owner files an application stating that they've cured, repaired, taken care of whatever the issues are that caused the rent reduction. If there are multiple services involved, meaning you had maybe a list of 5 or 6 items in your apartment that weren't maintained, maybe there are multiple items in the building, it may necessitate more than one restoration application, and I'll get into why as we go on before the rent is fully restored. When the owner files for the restoration and only some of the items are found to be repaired, the application can be granted in part, and only the items that are repaired would be found to be restored in that order. The rent will not be totally restored until all items are found to be repaired in a subsequent order. So we may issue one order and say that certain things were repaired, but in that order we would indicate the things that were not maintained. So if there are multiple items that cause that rent reduction order, you will not have to pay the full legal rent until all of the outstanding rent reductions for that apartment have been taken care of. In some cases, you may be in a situation where you've had multiple orders. And in cases like that, they're handled sequentially based on the owner restoring them. So if an early rent reduction order is restored, but there are later rent reduction orders, what may happen is you may end up with a partial rent reduction based on the difference in the effective date in those orders. They may, if they're close together, may not change your rent reduction at all if they're within the same guideline period. But if they're separated and you've signed other renewal leases in between those reduction orders, your rent may go up to the point where the effective date of a later order comes into play. Now, on these rent reduction orders, the effective date of the reduction is going to be the first month after the order was issued. And on a restoration, it's going to be the first month after the tenant is notified of the owner's application to restore the rent. Because there may be some retroactivity involved, if there are arrears on a rent restoration order, the tenant, you can pay that back in equal monthly installments equal to the amount of the rent reduction that was taken. So basically, because you went back a guideline and let's say your rent was reduced by $25, when the restoration order is issued, you would be allowed to pay back any retroactivity amount in equal installments of that same amount that the rent reduction was taken. For rent control tenants, it works a little differently because, as I said, you're given specific dollar amounts for the rent reduction. So if you have more than one item that wasn't maintained, let's say you had 2 items that weren't maintained, one item caused a $10 rent reduction per month, another item caused a $20 rent reduction. If only the item that caused the $10 reduction is restored, that is the only amount that would be added back to the collectible rent. And the owner would have to file another restoration application to get that other $20 restored once he fixed whatever that issue was. And again, because tenants in rent control apartments do not have leases, the effective date of both the rent reduction as well as any restoration cannot be retroactive. It's always going to be prospective. And it's going to be the first date, the first rental date after the issuance of the order. So there wouldn't be no retroactivity, and you would have to start either reducing your rent or paying your rent, rent restoration, the first monthly payment after the order was issued. In situations where we've issued where there was a vacate order and we reduced the rent to $1, the effective date of a restoration would be at the point that the apartment was restored to habitability and the tenant was able to move back in the apartment. And that would become the effective date that the owner could start charging the full rent. So now I'm gonna go into some of the documentation that's required in a service complaint and how some of that works. While this is not mandatory, we always advise tenants to write a letter to the owner or managing agent explaining what needs to be repaired. I know when I've counseled people, when I was doing counseling in the BRO, I would always advise tenants to take a walk around your apartment, make a list of everything that you have issues with, itemize it, put that in a letter to the owner. And there are two reasons why you want to do that. The first reason is, as long as you have pre-notified the owner and you want to maintain, you want to keep proof that you notified the owner, it cuts down on the time in which the owner has to respond to the complaint. That's the first one. The second reason is, once you submit that application and it's docketed, you cannot amend it and add other items to that complaint that are not being maintained. You would have to start over again and file a new complaint. And that's where you may get into the situation where you will have multiple rent reduction orders for various issues within your apartment. And the same thing goes for the building-wide application. It's always advisable to take a survey, make an itemized list, and give all of that information so that it all can be included in the complaint. As I indicated earlier, with heat and hot water, I want to reiterate, you have to have the HPD violation. So you would call 311, ask them to send out an inspector. Once their inspector comes out and sees that the heat is inadequate or the hot water is inadequate, they should be able to issue a violation. As soon as you get that violation, you would submit that with the complaint. In a situation like that, it's not necessary to have a separate letter notifying the owner of the violation because they would be notified by HPD when the violation is issued, so that doesn't become an issue in heat and hot water complaints. The last thing I would want to note is that, and this is dealing with tenant reps, and this is usually more of an issue with building-wide complaints, since multiple tenants can join in that complaint. If there is going to be a tenant rep, if you have a tenants association and you have a tenants rep, you would want to put in information stating that this is the representative and they're authorized to act on the behalf of the other applicants. There's also a notation on the supplementary signature form for building-wide complaints to indicate that there is a authorized representative. And it may not be a tenant rep. It could also be an outside advocate or an attorney if you have other legal issues involved. But you want to notify us in writing if there is someone that will be representing you. So, common notices. So what I'm going to talk about now are the things that go into the back and forth while the case is being processed. The first notice that you would get as a tenant, if you were the one filing a complaint, is the docketing acknowledgement notice. And this is a very important notice. This is a notice that tells you what your docket number is and the date that we received the complaint, and that it has been accepted for processing by the services unit. And a docket number is very important because using that docket number, whether you call us on the phone or go online on our website where there's a portal in which you can enter a docket number, that's the way we will be able to update you on the status of your complaint or assist you if you have questions about it. We can look it up in our system. The next notice is what we call a disposition notice. And this notice is sent if there is an issue with the application, whether there's a specific defect in the application that has to be addressed before it can be accepted and docketed, or if we only partially accept the application, you would get a notice of disposition and be given an opportunity to correct any issues with the original application that you filed. The notice and transmittal of the tenant's complaint, now that's the notice that goes to the owner. The way our case processing goes, and this is for service complaints as well as any other complaint type with this agency, is what we call a due process system. And that, like I said, it's service, whether it's a lease violation, an overcharge, we have to serve information to the other party. And the first thing that we serve is this notice and transmittal of tenant's complaint. It's sent to the owner. It has a copy of your complaint form. And as I said earlier, depending on the type of complaint and the severity of the issue, it notifies the owner that they have X amount of days to respond to this complaint. Conversely, when the owner files for his restoration, excuse me, if he has made all the necessary repairs, you would get, as the opposing party, a notice and transmittal, and you would have your 21 days in which you can respond and let us know whether or not he has actually made the repairs that he's claiming. The next thing you may receive would be a request for additional information. And this is to help confirm information that's in your complaint or to clarify something. We may ask, for instance, if you have a situation where the owner has done something and you now have to pay for heat or hot water, or if there's that type of allegation, we may want copies of utility bills. If there's a dispute as to whether or not you are the actual tenant filing the complaint, we may ask for you to submit a lease to show that you're actually the tenant if the owner is claiming that you are not the tenant of record in the apartment. If it's a dispute over ancillary service, say you had a storage facility in the building and the owner's claiming that that wasn't a service, we may ask you if there's something in your lease that indicates that you're being provided storage space or access to a space. There are situations where if you have a ground floor apartment, you may have a small courtyard behind your apartment, and in your lease it says you have access to that space, and maybe the owner stops giving you access. We may want proof that it was included in your lease. There may be various other things that we may ask for as well, but it's very important when you get a request like that you respond to it timely and as completely as possible, and we try to give you enough time to do that. The next thing is a notice of inspection. The notice of inspection is something that does not come from the examiner that's working on your case. It is sent directly from the inspection unit, which is a separate unit within this agency. And that notice of inspection is going to give you the date that the inspector is going to come, and it will give you the inspector's contact information, their name, and a phone number where they can be reached. The inspections usually are scheduled at minimum 2 weeks in advance. So you would have plenty of notice to deal with or to respond to that notice of inspection. The last thing I'm going to talk about in terms of common notices is an answer to notice or application. And the answer to notice or application, again, we work on a due process system. And during the course of dealing with the complaint, if one party states something or submits information and makes an allegation, the other party is given an opportunity to respond. So generally speaking, as just to give you the example I gave before, where there was a storage facility, the tenant is claiming the owner removed that storage facility availability, and the owner saying, well, they never had that in the first place. If the owner makes that allegation, you would be sent the that allegation along with this answer to notice, allowing you the opportunity to respond to submissions by the other side. And again, this is typical of all of our case processing in order to give both parties an opportunity to submit evidence in full and to respond to any factual or substantive information provided by the other side. I'm about halfway through. I don't know if you want to take a little break or if you just want me to continue.
Yeah, I think if want to take like up in 5 minutes, does that sound good to you?
I'm sorry?
How does 5 minutes? Does that sound good to you?
Yeah, we can take a little 5-minute break and then I'll continue.
Okay, great. So we'll be back at 2:46.
Okay. What just happened? Are you ready to start up again, Jessica?
Yep, that sounds great. Thank you.
Okay, so let's continue. So now we're going to go into additional information, and this is just general stuff regarding the case and filing. Now, two of our case types, individual apartment and heat and hot water complaints, can be filed online. Meaning you can go onto our website. You don't have to print out a paper form or do the form online. You can actually do all of the information online. And this is especially important in cases where we have code red complaints. You can indicate on the online filing that it's a vacate situation or a code red situation. The online filings are automatically docketed and then served to the owner within 2 days of being filed. So we get them out to the owner and they're made aware that a case has been filed very, very quickly. For code red cases, an inspection is automatically requested after it's been 10 days after it's been docketed. So, as I said before, they're prioritized, and as you can see, we start the inspection process fairly quickly. Now, one thing you should note, regardless of whether you file online or on paper, once they're docketed, they're still going to be processed pretty much the same. Now, the online filing will be docketed more quickly, but it's still going to go into the queue unless it's a code red situation, which requires expeditious processing. So, with that said, we still strongly advise that you file online if it's available for those, like I said, for those two case types, for the individual apartment case type and the heat and hot water case type. Now, even though you can initiate the case online, we do not communicate the processing of the case via email. So if you have additional information or something to supplement your case, you cannot attach it to an email and submit it to our agency. It still would have to be mailed in, excuse me, to our main case processing office in Queens. So now there are a lot of factors that could impact the way a case is processed and how long it may take to process a case. Those things would include extension requests, ownership changes, if an inspection has to be rescheduled or canceled, and building or apartment status disputes. So let's talk about the extension request situation first. Generally speaking, if someone asks for an extension, we will just automatically just give them a 30-day extension, meaning they'll have an extra 30 days to either submit information or respond to something based on that extension request. Now, if someone needs another extension request after that, it's really going to depend on what the circumstances are. For instance, if the person needs to access some old documentation, maybe it's old utility bills or something that isn't readily available and they're having a hard time, and they can show that they're having a hard time getting it, that may warrant an additional extension. And they would go in 30-day increments. We don't go beyond 30 days, generally speaking, in granting an extension. So the bottom line is the first one is basically a free extension. We won't really question it. If you say you need more time, we'll just automatically say, okay, you have an extra 30 days. But once you have to, or if you have to ask for an additional extension, then it becomes a situation where you're going to have to justify why an extension should be granted. We do notify you whether or not the extension is granted or denied if the case is already assigned and currently being processed. So if you've gotten notices from the examiner, the case is being actively processed at that time, and you submit a request for an extension, we will notify you as to whether or not it was granted or denied. But if your case is still in a situation where it has not been assigned, you may not necessarily get a notice telling you that it was granted, because usually by the time it is assigned, it's basically a moot issue. In 30 days, more than likely would have already transpired. So that's how the extension process works. Now, with changes in ownership, the impact that has is you basically have to almost start over again. If there's a new owner, it's possible that we may have to reserve them with a copy of the complaint if it wasn't given to them by a prior owner. There may be additional documentation and information that we need to request from a new owner, and that's going to necessarily delay the processing of your application. So that is always going to have that type of impact. As far as canceling or rescheduling an inspection, there are two things that have to take place when that situation arises. Well, the first thing is if you do have to reschedule or cancel an inspection, it's definitely going to prolong the processing part of the complaint, since the inspections are going to be pushed back, and generally speaking, until the inspection report is submitted to the examiner, the case is not going to be able to really go forward or come to a conclusion. If you are in a position where you do have to reschedule, the first thing you should do is you should reach out to the inspector at the number that's listed in the inspection notice. As I said earlier, when you receive that inspection notice, it always will contain the inspector's name and their contact information. So that should be the first thing you do, is reach out to them. At the same time, you should also send a letter to the processing unit addressed to your docket number, indicating that you need to reschedule or cancel that inspection. You need to do both of those things. You need to reach out to the inspector. You also need to put in a request in writing to reschedule that inspection. Again, you're normally given at minimum a couple of weeks advance notice of the inspection. And if you know that you're not going to be there, it's not a good time, or you'd rather reschedule it to another date, you should immediately reach out to that inspector, and you should immediately put it in writing, RE your docket number, to the case processing unit. As far as how we treat requests for rescheduling cancellations, we have a limited number of inspectors, and they usually have a pretty full schedule. So that situation is somewhat limited, and it's generally granted for good cause, which is another reason why you should put it in writing, and you should explain specifically what the circumstances are that would make it so that you cannot be there for the inspection. And I just have to note that as far as this type of inspection is concerned, it's generally dealing with something inside your apartment where the inspector will need to get access in order to see the conditions that are in your complaint. So someone would have to be home to let them in and give them the opportunity to actually do the physical inspection. In some cases where it's a building-wide complaint and it's in a common area, and they don't need to get specific access from a particular tenant, that would not be an issue because they don't need to notify that they're going to inspect or actually have the tenant be there. The last thing is dealing with building or apartment status disputes. And this is something that comes up usually pretty early in the process. And it would be a situation where you as a tenant, you file your complaint, we get it, we docket it, we send it to the owner, and the owner's first response is, hey, this isn't a rent stabilized building, or this apartment isn't a rent stabilized apartment. Maybe the owner's claiming it was deregulated, or maybe he's claiming that it was never rent stabilized, or the building wasn't rent stabilized. What that does is that will necessitate us putting a hold on the processing of the service complaint until we can determine whether or not we have status. And it will kind of open up a side complaint where we will take the necessary steps, request the necessary documentation from both or either party to give us the ability to make that determination as to whether or not we have jurisdiction, and if in fact the apartment is subject to rent regulation. And again, that's going to significantly delay the process. So now we're going to talk about enforcement. what steps are taken to get the owner to make the necessary repairs, and what happens if the owner doesn't make the necessary repairs. Um, Keep in mind that the whole purpose of this process of the rent reduction, rent freeze, the inability of the owner to collect increases in rent, are all designed to compel the owner to make the necessary repairs. They're not designed to be necessarily be punitive against the owner, but to incentivize the owner to make the repairs that will make the apartment habitable and take care of whatever issues the complainants may have. So one of the first things that you would deal with would be an overcharge. And the overcharge will come into play in a situation where the owner refuses to give you the rent reduction that's ordered when the order is issued. The order will specifically tell the owner that the rent is reduced, frozen as of this effective date, and from that point forward, the owner is supposed to calculate and then bill you based on the amount that they're allowed to collect after after the rent reduction order is processed. In addition, since the effective date of the order is generally right after the case is filed by the tenant, there is going to be some lag time between that date and the date that the order is issued. And what does that mean? That means that there's going to be some retroactive monies owed to the tenant based on the rent being reduced and frozen in that interim period. If the owner does not want to give the tenant that money either as a credit on their rent or however that transaction would be processed, the tenant would then again be in a situation where they would file a rent overcharge complaint. Another situation, and this is slightly in a different area, is a situation where you as a tenant find out that there was an order issued maybe prior to your occupancy that you were unaware of, that has never been restored, and that technically the owner has not been allowed to get a rent increases. In situations like that, because the order is still in force, that would necessitate you filing a rent overcharge in order to compel the owner to, number one, deal with that case, as well as deal with the fact that he should not have been increasing your rent while that case was still in existence. So that's where the overcharge part would come into. Next, we have non-compliance proceedings. And this deals with not a situation where the owner is refusing to reduce and freeze your rent, but it's when the owner, even though he may be adhering to the rent reduction order, it does not fix the underlying issue that caused the rent to be reduced in the first place. Generally, when the order is issued, the owner is given 30 days to make the repairs. After those 30 days have passed, if the owner has not made those repairs, the tenant can initiate what's called a non-compliance proceeding. Now, that is a separate form that the tenant would have to file, which is a non-compliance form. And that would go to a separate unit, separate and apart from the services unit, which is a non-compliance unit. That's where it's screened, docketed, and served on the owner by the compliance unit. Once that proceeding has been initiated, the owner is going to have 30 days to respond to that. And their response can vary. They can claim that they've complied with the order and they've restored the services. And if that is their response, the compliance unit at that point will order a follow-up inspection to confirm whether or not the owner has actually made the repairs. And the tenant will be notified of this, especially if it's a something within the apartment whereby the inspector will need the tenant to give them access. The other response the owner can give in the non-compliance proceeding is if they are claiming that the tenant has not allowed access to the apartment. And if that is the owner's defense, the owner has to substantiate that. And how does he substantiate that? He has to provide at least 2 letters as well as proof of mailing to the tenant attempting to arrange that access. So he has to show us that he has asked the tenant multiple times, a minimum of 2 times, to grant access to that apartment and that the tenant has refused. Now, those letters can't be sent out a day before. He has to give the tenant adequate notice, and we tell the owners that that notice has to have been at least 8 days prior to when the owner is asking for that access. The letters have to be sent by certified mail, return receipt requested, so that we have proof that they were sent to the tenant and that the tenant actually got those requests for access. Now, if the owner can substantiate that, the next thing that would happen is we would request what's called the no access inspection, whereby the inspection unit would notify the tenant that we are going to conduct a no access inspection, and the owner would be notified. The owner would be required to be there with the inspector, as well as be in a position to be able to effect those repairs. So that's what happens if the owner alleges no access. And let me back up with that, because that's something that should have been presented a little earlier as well, is that this can also happen during the normal course of the case processing, whereby your tenant, you filed your complaint, you're complaining that the owner won't fix something in your apartment. If the owner during the normal case processing alleges that you as a tenant are refusing access, it would follow the same exact procedure. But instead of it being the non-compliance unit, it would just be the regular rent examiner who would request the same type of proof, as well as order a no access inspection. Lastly, in the compliance proceeding, if the owner lets us know that he hasn't complied, we will issue a nominal civil penalty and give him some additional time to make the necessary repairs, and the tenant will be notified. And if the owner again does not make the repairs, we at that point would have the tenant refile their compliance case, and the case would be escalated to a housing specialist. And what the housing specialist will do is a couple of things. They can order a further inspection just to make sure that the conditions have not been maintained and not been fixed. They can reach out, try to contact the owner and try to mediate it and see if they can get the owner to make the repairs without there being a further escalation in civil penalties. If the housing specialist, after sending the inspection, sees that those conditions still exist, and the mediation isn't working, they'll send a copy of to the owner, letting them know that they're still not in compliance. They'll offer the owner a settlement of another civil penalty and give them an additional amount of time to comply. If the owner still does not want to comply, at that point, the enforcement unit will start a hearing process. And once the hearing process starts, that's when we start escalating the fines to an initial penalty of up to $2,000 for the first offense, and up to $3,000 for each subsequent offense. So if there are multiple items that the owner is refusing to repair, and it gets to the point of the enforcement unit and a hearing, as a result of that hearing, at $2,000 to $3,000 per item, those penalties can escalate fairly quickly depending on the number of conditions that exist in that rent reduction order. And these civil penalties, they don't go to the tenant, they're paid to the state, but they are assessed to the owner. And this is in addition to the rent already being frozen and reduced, and whatever other penalties would fall under if there was an overcharge case or anything else that would cause the owner to have to pay the tenant that plus damages. And the last thing I'll say about the overcharge, one thing about the overcharge is that since it is a case as a result of the order and also with the change in the rent laws, it would automatically be a treble damage award for any overcharge resulting based on a rent reduction order. All of that being said, most cases, once they get to the compliance unit or the enforcement unit, they are settled and the owner does make the repairs, and he'll agree to pay a fine once it is escalated to that point. Now, there are some related proceedings that you should be aware of in dealing with this case. And these related proceedings also apply to other cases as well. The first thing is a petition for administrative review. And what that is that because this is an administrative proceeding with the state, either party that does not agree with the decision that was made has the right to file a petition for administrative review, a PAR case. And that is a written form that has to be filled out and filed, wherein you have to state specifically what the errors were in the case, whether they were in law or in the facts of the case, that is the reasoning behind why you wish to appeal this order. And it has to be issues that were dealt with during the processing of the case. You cannot use the appeals process to submit information or evidence that wasn't a part of the original proceeding, unless that is part of the par itself or is under good cause. And what I mean by that is if you have evidence that as part of the par you weren't notified of something which didn't allow you to submit documentation that would have supported your case, like say if you didn't get a notice, or if you responded timely but that information wasn't accepted, things like that that have to do with the specific processing of the case. Now, if you as a tenant who's received a rent reduction order and that order is in place and the owner files a par and is challenging that case, while that par is being processed, the rent reduction still stands and still stays in effect. However, if because of that rent reduction order, there were monies owed to the owner based on arrears, the owner would not have to pay those arrears until the administrative review has been decided. So you still get to keep your rent as frozen. You just won't get any of that interim money that I talked about earlier based on when the case was filed and the order was issued, and if the owner owed you back money because of that. Conversely, if you as a tenant receive a restoration order and you file, and that order was granted and you don't agree with it and you file a par, while the owner can collect the rent that was restored under that order, any retroactive money that you would owe to the owner would also not be collectible until that par is decided. The par itself can do one of three things. It can either affirm the original order, basically saying that order was correct. It can revoke the order in part or in full, or it can modify the order. And the par order is issued by our par unit and is signed by the deputy commissioner. Now, while pars don't have a specific effective date, they just have an issuance date, but it's possible that within the par itself, if it modifies the order, it can change the effective date of the original rent reduction order, but that would be indicated in the par. The next item would be an Article 78 proceeding. And what that is basically in a situation after the par issue is decided, if you are still aggrieved and you don't agree with the par decision, you could file what's called an Article 78 proceeding, which is a legal proceeding that is not between the party and the other party and dealt with by us, but you would be challenging our agency and the ruling in the par, and that would result in a court proceeding in the appellate court, because you would essentially be suing the state agency. The last related proceeding would be what's called the request for reconsideration. And what a request for reconsideration is, if there's an order issued by the agency And that order was issued as a result of an illegality, in what we call an irregularity in a vital matter or fraud. You can request that your case be reconsidered. And that's something that is done. There's not a specific form for that. It's something that's done in writing. You would have to make your case to the rent administrator that signed the original order, and you would have to state what your reasons are, what the illegality was, or what the irregularity in a vital matter was, or what the fraud was, that would make the case eligible for reconsideration. Those are the main related proceedings to a case. And those three things apply to basically all of our administrative orders. Again, whether it's the service order that we're talking about today, or one of the other administrative orders, such as a lease violation or an overcharge. So that's basically everything that we have today with regard to our services process and information. So now I see it's 3:22. I'm going to give you resources in terms of how you can contact us. Our website is hcr.ny.gov. We have an info line where you can call in at 833-499-0343. We have a portal by which you can submit a question, and that's portal.hcr.ny.gov. And this is our general contact number, hcr.ny.gov/contact us. So at this point, I believe, Jessica, you're going to moderate a Q&A for the last 30 minutes or so.
Hi, yeah, so we have some questions. Hi, can you hear me?
Yes, I can hear you.
Okay, great. I know that there might be some problem with my sound. Some people said that before, but I'm working in the office and our system is not quite perfect yet. So apologies for my sound. I'm going to read the question that have been placed in the chat. So feel free to keep adding questions at the bottom. The first question we have is,
before you start, I saw that someone asked to repeat the contact information, so I'm just going to quickly repeat that again. Our website is hcr.ny.gov. Our rent info line is 833-499-0343, where you can call in and get information. And our online portal for asking questions is portal, portal.hcr.ny.gov.
okay, great. And we can post that information on our website also, where the announcement for this meeting is.
And I'll leave this page up.
Perfect, thank you. So the first question that we have is, if a tenant has filed 2 rent reduction orders, one due to repairs, then a few months later, another due to no heat and hot water. Both cases were approved and a rent reduction was ordered. How can you determine what should be the rent the tenant should pay?
Okay, it's gonna be based on the dates that the orders were issued. And they're gonna go in sequential order. So if the normal rent reduction order was issued first, you go by that effective date, and that's where you're initially going to have your rent reduced and frozen. what will happen then is if that case is dealt with, the owner makes the repairs, he files for restoration, and he gets that restored, then it will go to whatever the effective date is of the heat and hot water complaint, unless that has already been restored prior to the other case. So anytime you have multiple rent reduction orders, you may have one for your individual apartment and then a separate one for, as a building-wide, they're always going to be based on whichever one was issued first, and then it will depend on when they are restored. So they may not always be restored in sequential order, but your rent reduction is always going to be whatever order is still in effect that has the earliest effective date.
Great. The next question says, who do you contact when you have questions about a decision that was made on a complaint?
Well, it depends on what you mean by questions. If you're not understanding the order itself, you can call the rent info line, you can call one of the BRO offices, or you can make an appointment and come in and bring a copy of the order, and one of the examiners can help you understand it, explain it, kind of work out the information that's contained in the order. They can answer those kind of questions. If it's a situation where you're actually disputing the order itself, that would be one of the last things I was talking about, which would be the PAR process, where you would have to file a petition for administrative review and indicate what you're objecting to and let that process play out. So it really depends on what you're questioning.
Thank you. The next question that we have is, they removed a non-repairable stove from our kitchen and replaced it with a new stove, but much smaller than one we previously had. How can we, so we can't really talk about personal situations. Maybe
right, look, what I can say is this: in general, when an owner is seeking to restore and they have to replace or repair something, it has to be an item similar to the item that's being replaced, number one. Number two, if we're talking about a repair, it has to be in good workmanlike order. To give you an example, let's say you had a leak which caused damage to your wall, maybe paint peeled, maybe there was a crack. The owner can't just fix the leak and leave the wall. He would have to fix the leak and then repair the wall so that the wall is back to the condition that it was before the leak occurred. Again, if it's a physical item like a stove or refrigerator or something like that, it has to be something that's comparable to what was there prior, without getting to the specifics of your individual case. If you believe that the repair or replacement is inadequate, that's something that you would raise during the restoration process, or during or you can discuss or with the inspection.
Great. The next question is, the landlord continues to leave my spouse off the lease renewal. What can I do to get them on?
I'm sorry, what was that?
The next question is, the landlord continues to leave the spouse off the lease renewal. What can I do to get them on the lease?
Okay, what you would do is you would file a lease violation complaint. That's basically it. You have an absolute right to have your spouse put on a lease. If the owner is refusing to do so, you would file a lease violation complaint, in which case, if we find in your favor, we'll order the landlord to do it. And similar to the compliance proceedings with the service complaint, if the owner still refuses, there's a compliance process for lease violations as well. And it follows kind of similar process, a little bit different because you're not talking about repairs, but there are compliance proceedings that deal with fines and things like that, and mediation if the owner still refuses after we issue the order.
Great. So the next question says, do rent reduction orders have a statute of limitation? A rent reduction was filed and ordered in 2013. The owner never filed a restoration application. However, the issues that they repaired are again an issue that needs correction again.
As I said earlier, no. If that order was never restored, it's still somewhat enforceable. What you would have to do is you would have to file a rent overcharge complaint. And then what that would do is basically we would issue an order setting the rent at a certain level based on that rent reduction and freezing it coming forward. And the owner would be compelled to do a restoration. Now, if this was something that was done by a previous tenant, it might be conceivable that you could file your own rent reduction order, but it might not be necessary if it's the exact same conditions. But the bottom line is, once a rent reduction order is issued, the owner has to get a restoration in order to legally increase the rent, regardless of changes in tenancy or how long ago that rent reduction order was issued.
Great, that's great news. Can you tell us, the next question is, can you get an extension on responding to a PAR?
I believe you can, but it would have to be for good cause, and you would have to request it from the PAR unit as soon as possible and give them an opportunity to respond. But generally speaking, all of our case processing units do allow for at least one initial extension without too many issues involved.
God, every time I ask a new question, I have 4 more at the bottom. So we have a lot more questions. The next one says, can you file a rent reduction if your lease and it increased 300 in a rent stabilized unit? I don't understand the question.
Well, what I would say is this: filing a rent reduction is the only relation it has to a lease is the reduction is going to be based on whatever lease is in effect. So if your lease was renewed, you filed a rent reduction complaint, and regardless of the amount that it was renewed, it's going to roll back to the previous lease. If you believe that, and this is separate and apart from the rent reduction itself, that the owner's charging you more than he should be charging you, regardless of any services in the apartment, you should file a rent overcharge complaint. Request the rent history and the relevant information for your apartment, and just file a rent overcharge.
All right, moving on to the next question. It says, is it true that the tenant can include services that were provided but not registered by the owner with DHCR? For example, building security cameras that are no longer operating.
Yes. It's not, the services aren't going to be based on necessarily everything that was included in the initial services application. It could be something that was given when the tenant moved in. As I said before, if you move into an apartment and the owner says you can have basement storage, and he puts it in your lease, and you're there for 2 years or 3 years, and then all of a sudden he decides he doesn't want to give you the storage anymore, you can file a case against that. If he installs a laundry room in the building for the use of the tenants, it's possible that if he later on decides that he's gonna take it out, or if it goes into disrepair, the machines stop working, it could be possible that you could file a complaint about that as well, and that may not have been something that was in the original RR3 when the building first filed its initial services form when they registered. So it's not always going to be based on that.
Great. The next question says, what if the individual that the owner sends to make repairs is high, drunk, rude, disrespectful, making lewd comments, and does inadequate repairs? Can the tenant refuse access based on those problems or issues?
Well, that's going to be on a case-by-case basis. What I always advise tenants is to document everything that happens in a situation like that. As far as the inadequacy of the repairs, that's something that would show up when we send our inspectors out. So regardless of the condition of the person making the repairs or their conduct, if they don't make the repairs correctly in a workmanlike manner, that's going to show when we inspect. So we'll see that anyway. But if there are other issues like the ones described, document it and let us know. Put it in writing and let us know, and document it as best you can.
The next question says, does DHCR accept HPD printouts as proof of notice to landlord about conditions in the apartments?
If you're talking about HPD violations, I believe we do. And the reason being is because when that violation is issued, the landlord gets a notice from HPD. So it could substitute for the written notice that's required, or not required, but suggested when filing the complaint. And this is separate and apart from the requirement under heat and hot water. We're talking about just a regular HPD violation, whether it's a A, B, or C violation.
Thank you. The next question says, please verify, is a rent reduction done only for rent regulated apartments?
Yes, we only have jurisdiction over rent regulated apartments, either rent stabilized or rent controlled. If you're in a non-rent regulated apartment, you're gonna have to go through court. You may have to file an HP action, or get the landlord in court before a judge to compel them to make repairs that they're not making. As I said, we don't have jurisdiction over anything that's not under rent stabilization or rent control.
Great. So the next question says, how does HCR handle a rent reduction application where a 2-bedroom apartment became a 1-bedroom apartment after the owner repaired fire damage during a vacate order? This is a substantial reduction in services.
That's a little hyper-technical for this conversation, but what I would say is that's gonna, in general, a situation like that is gonna vary based on whether or not the owner can substantiate how they did it through the Department of Buildings and stuff like that. It's not a question that I could easily answer. It's something that we would just have to look at as far as the process. But if I were in a situation like that, I would advise the tenant to get in contact with like Department of Buildings and things like that, to see if by changing the structure of the apartment, the owner committed a violation with them, and then submit that evidence to us to show that he reconfigured the apartment illegally.
I'm not sure that I understand the next question, but I'm going to read it and you tell me what you think. It says, can you possibly explain the differences or potential barriers if a tenant attempted to complete this for a rent controlled, stabilized, rent regulated? I'm not sure what. So I'm going to skip that. Sorry.
Okay. All I was going to say is that The only difference between a rent control and a rent stabilized apartment in terms of rent reductions are concerned is the manner in which the rent is reduced and frozen. Rent control apartments, it's specific dollar amounts based on the actual items that are found to not be maintained. Rent stabilized, regardless of the items not being maintained, it's a reduction and freeze based on the most recent guideline. That's the only difference.
Oh, great, that makes sense, perfect. The next question says, who decides which complaints are code red or code blue? Is there a chart somewhere that lists what would make a case code red or blue?
As I said, I think I gave some pretty specific examples earlier as far as what's code red, but it is going to be on a case-by-case basis. There are certain things that are automatically code red, such as if you're forced to vacate and have a vacate order, if the apartment isn't habitable, again, if it's something like a collapsed ceiling, a collapsed wall, a floor, a cascading flood, like say if the apartment above you, the pipe broke and your apartment is being flooded, and you have a cascading flood. I believe an inoperable toilet was one of the things, or absolutely no running water, or if you have absolutely no electricity in your apartment for whatever reason. It's things like that. There isn't a specific list that we put on our website or would be able to send you, but those are some examples of the types of things that are considered code red.
Great, so the next question says, how do you calculate the reduced rent for a Section 8 tenant in a rent-regulated apartment?
There's no difference. It goes back by guideline. The thing that you have to understand is that if you're receiving any type of rent subsidy, that's not the issue with us in terms of our regulations. That's a question of how the rent is paid, not how much rent is paid. And whether you're paying 20% and whoever else is paying 80%, it doesn't matter. The rent reduction is still going to be one guideline increase if you're in a rent stabilized apartment, or whatever the dollar amounts. And where that money falls is between you and whoever is subsidizing it.
Great, thank you. The next question, we still have a lot of questions. So the next question says, if the tenant gets a rent reduction and the landlord makes all repairs, does the tenant pay the rent back?
As I said before, it's going to be based on the effective date of the restoration order. Once the owner makes all of the repairs, they still are compelled to file for a rent restoration. What I've always advised tenants, what I tell my counselors to advise tenants is that if you know the landlord has made the repairs and the repairs are solid, once you get that notice that he is applying to restore the rent, you should know that when it's granted, it's going to be effective the first rent payment after the date of that notice. So if that notice is on March 15th, then, and it's granted, the full rent's going to be due starting April 1st, even if that restoration order isn't granted until September. So knowing that, once you get that notice that he's filed for restoration, at that point, even though you do not have to give it to him, you should start setting aside the difference between your reduced rent and what the full rent is, so that you can pay it back to him. In addition to that, as I also said before, in general, you're allowed to make the payments in the same manner in which it was reduced until any retroactive is fully paid back. So I think I gave the example during my presentation that if your rent was reduced by $25 and you get a restoration and there's like 6 months of retroactivity, you would pay that extra $25 for the next 6 months to deal with that retroactive. And that's the general practice that we allow on a restoration.
The next question says, is there a chart that lists what the dollar amount reductions are for reduced services in rent controlled apartments?
No, not that I'm aware of. I could could check with the services unit and get back to you, but I don't know if there is or not.
Great. So the next question says, if the appliances are old and dusty, can they be replaced?
Not just because they're old. They have to be in a non-working or inadequate condition. There are some caveats with how they're replaced as well. One thing you need to understand is that owners are not obligated to replace an old appliance with a brand new appliance. They can replace it with a refurbished appliance. The only thing the owner is required to do is make sure that it is similar to the item being replaced. So, like, I don't know, I may be way off in this analogy, but if you have a 20 cubic foot refrigerator and it breaks down, the owner doesn't have to buy you a brand new 20 cubic foot refrigerator, but he could give you a refurbished 20 cubic foot refrigerator, but he can't give you a 10 cubic foot refrigerator, whether it's new or refurbished, because it's completely substandard to what you previously had. When you get into the issue of appliances being replaced with new, you get into the individual apartment increase situation, whereby owners are allowed to charge an increase in rent when they give you a brand new appliance, but you have to give them your consent. So that's a negotiation you could have with the owner. If you don't want a used appliance or refurbished appliance and want a brand new appliance, you can come to an agreement with them. But again, they're not obligated to give you a new appliance. They're only obligated to replace it with something that's working and that is basically the same as what you had.
Great. So the next question says, my rent stabilized apartment is not registered with DHCR after being reconfigured from a 1-bedroom to a 2-bedroom. We believe we're paying an illegal rent. How does DHCR process and determine rent reduction and rent overcharge application for non-registered or Frankenstein apartments?
Well, the first thing that we would have to determine is whether or not it's subject to rent regulation. That would be the first thing. I mean, you could file a complaint as normal. You would file your rent reduction based on decrease of services. You would file your rent overcharge because you think that he's overcharging you. Again, as far as the physical reconfiguration of that apartment, it's not under our jurisdiction. It's more in the Department of Buildings, and maybe there's some code violations involved there, but that's something you would have to address with them. Now, if the owner comes back to us and says, hey, this isn't a rent stabilized apartment, I did X, Y, and Z, and it's deregulated, that would have to be dealt with first. And then once we determine whether or not it's under our jurisdiction, then we'll determine whether or not we have the authority to give you a reduction in rent and a rent freeze, and the authority to recalculate your rent in the event that you are actually being overcharged.
Great. The next question says, how much time should you give a landlord to fix the repairs before submitting a rent reduction?
Really, that's up to you and your relationship with your landlord. Generally speaking, you can, send them a letter, notify them, give them as much time as you think is reasonable for them to respond. When we issue our orders, we give the landlords 30 days before you can file for non-compliance. So that's what we feel is appropriate, and then subsequently we have other amounts that we'll give in the compliance proceedings and things like that. But it really depends on your landlord, your relationship with them, whether or not they're competent and responsive to your complaints.
All right, we're reaching the end here. 3 more questions. The next says, can you file a rent reduction when your gas has been shut off for 2 years?
When your gas has been shut off by whom?
For 2 years.
Oh, yes, definitely. If you don't have gas, you can file for a rent reduction. Now, if Con Ed came in and they red tagged your stove, it may be an issue of having to have your stove replaced. If there's something defective in it that won't allow them to turn the gas onto it. But yes, you can and should file an application for rent reduction. The owner would be compelled to make whatever repairs necessary so that your gas can be cut on, whether it's replacing or repairing your stove.
Great. The next question says, landlords don't always register the correct rent with DHCR. Why doesn't DHCR in general mandate they report the rents?
Why don't we mandate what?
That they report the rent. I imagine she means the correct amount of rent.
Well, the landlords are required to report the rent that they are collecting as of April 1st of every apartment under rent stabilization, with the name, the lease information, and the amount of rent that they're collecting. The law also requires them to serve a copy of that to the tenant. So those mandates are already there. If you are in a situation, though, where the landlord isn't giving you the annual registration, or you believe that the information that he's submitting to our agency is not correct, that's where you can do a couple of things. If it's an issue of him charging you one amount and then putting a different amount on the registration, you can ask him to amend it. And if he doesn't want to amend it, and if there's an issue, you can file a rent overcharge. And basically, the rent overcharge is where you're going to come in anyway. If the landlord isn't registering at all, again, that would be subject for an overcharge filing. Anything dealing with rents and whether or not he's collecting the proper amount and not registering, or you get a rent history and you don't think the prior registrations are accurate or believe you're being overcharged, you file a rent overcharge complaint.
The next question says, can a tenant submit multiple applications for separate rent or repair issues, but submit and mail them together?
You can, but unless it's building and service, your best course of action is to put everything in one complaint. For instance, and I'll tell you why. The reason being is because, number one, it speeds up the processing in terms of having to process more than one complaint for the same issues if they're all, say, within the apartment. Number two, once we issue an order, like we've had the inspection, we found that however many items they are, that they're not being maintained. In order for the owner to get his rent restored, he has to fix everything in that underlying rent reduction order under rent stabilization. The other thing is, if you give us multiple complaints, and you're going to have multiple effective dates, and it gets very, very confusing trying to figure out, okay, now this one was restored, now what rent do I pay now, and that one was restored, and what rent do I pay after that? One complaint, one effective date, one restoration, that's it. And that's, like I said, that's if it's all either inside your apartment or outside apartment. Of course, if you have some items inside your apartment and sometimes some items outside of your apartment, you do have to submit different complaints because there are different types of issues. One is a building-wide and one is an individual complaint. But if they are all in the same place, either inside or outside of your apartment, you are best served by filing them all on one complaint form.
Great. So the next question says, if a rent stabilized apartment has a lot of serious violations and is only barely habitable, would DHCR order a rent reduction to go back to the guideline increase only? Or would they consider reducing to $1 a month or some other reduction amount?
It really would depend on the inspection and on what the inspector finds. The dollar amounts are usually for situations, excuse me, where the tenant actually has to vacate. But I would say it's possible, but I don't want to give a definitive answer on that because it really would depend on the circumstances.
All right, two more questions. If a rent reduction is granted, but the landlord has failed to provide a rent-regulated tenant with renewal leases for several years, does the rent revert to the amount in the prior lease term or the amount of the last lease that the tenant was actually offered?
It's going to be based on whatever lease is in effect at the time that the rent reduction order is issued. Now, if you're in a situation where you have a lease, like let's say the last time the owner offered you a renewal lease was 5 years ago and he hasn't offered you a renewal lease since, that's the lease that's going to be in effect when that order is issued. When an owner doesn't offer a tenant renewal leases, the owner isn't entitled to rent increases for that period. And if and when he does offer a tenant a renewal lease, let's say it's 3 or 4 years later, he's not entitled to those in those other increases that would have occurred had he been giving them leases as he was supposed to. He would only be given the choice of either the guidelines that are in effect at the time that he offers the tenant the lease and it takes effect, or the guidelines that were in effect at the time that he should have offered the tenant the lease timely, depending on which one is lower. The tenant would always get the benefit of the lower guidelines, but he doesn't get those intermittent guideline increases, number one, and number two, as I said before, the rent reduction order is going to be based on whatever lease is in effect at the time that the order was issued. So if that's a 3 or 4 year old lease and the owner hasn't done anything since then, it's going to revert back to the last guideline that he was legally able to collect.
And for the final question, where do we get a rent history?
You can get one by any of those contacts that I gave you, the rent info line. You can call and ask for a rent history. You can call any of our borough rent offices. The numbers are on our website on the contact us page. And that portal, portal.hcr.ny.gov, you can go on there and there is this, the ability to quickly submit a request for rent history, and those requests are assigned on a daily basis and responded to by my staff.
Great. Thank you so much, Derek. This presentation has been very, very informative and helpful, and we appreciate you taking our very good questions. Thanks to the audience for joining us today. I will say that the recording will be available on our website a little bit later today. Also check out our website for some other workshops that we have coming up in the next couple of weeks. You can subscribe to our newsletter on our website. And again, thank you so much, Derek, for that presentation. It was very helpful for us. and have a lovely day, everyone.
Thank you so much, Jessica, and you too, Nipa. It's a pleasure, and thank you for inviting me. Take care, guys.
Thanks, you too. Take care.